All rise. The Court of Appeals Division 1 is now in session.
Good morning and thank you. Please be seated. This is the time set for oral argument in 1 CA CV 160468, WD at the Canyon versus HONGA et al. Each side is allotted 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal, but if you wish to do so, appellant will need to keep track of the time by using the podium clock. Out of respect for counsel, I ask that those in attendance to make sure that your cell phones are off or on vibrate. Counsel, we have read the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present your oral argument. And as you all know, proceedings are being recorded and will be posted later onto YouTube. Before you begin your argument, please state your name and the party you represent. With that, the appellant may proceed.
Good morning, Your Honors. May it please the Court, Robert Bernheim, Farhang and Medcoff on behalf of the appellants, WD at the Canyon LLC, and Mr. Jim Brown. I'm here with my colleague, Mr. Roscoe Mutz, sitting at the appellant's table. I will ask that I get to reserve some time for the rebuttal, and I will track that appropriately. And also, in light of the many legal arguments that are involved in this particular case, I will skip over any factual background, and if there's any questions, I just ask that you point me in the direction of whatever the issue may be. Off the bat, I'd like to try to knock out two of the issues, which I think are relatively straightforward at this point. The first being the tribal court exhaustion issue, which was raised by the trial court judge below. That's a moot issue now. I don't think that is disputed by the other side. The decision came out while the case was on appeal. So any issue about whether or not the procedure should have gone through the tribal court is not really an issue anymore. The other issue, which I believe should be very quick and easy for us to take care of, is the tribal sovereign immunity issue. We submitted supplemental authority of a U.S. Supreme Court case that was issued earlier this spring, Lewis v. Clark. That case was pretty much undeniably on point for this situation. Any time that a lawsuit is filed against individuals in their individual capacity as opposed to their official capacity, which is the situation that we have here, tribal sovereign immunity just simply does not apply.
So sovereign immunity then only depends on how you sue someone then. So sovereign immunity doesn't mean much then.
According to the U.S. Supreme Court, not really, and that's with respect. I apologize. Go ahead.
So if there is no question, and I assume that you believe there is a question, but if there is no question that the tribal member is acting as a part of the governance of the tribe, acting on behalf of the tribe, if they're sued in their individual capacity, then they can't claim the sovereign immunity. I just can't believe it's that simple.
And in fact, it really is that simple. The key issue is whether or not the tribal coffers will be the one that ultimately is responsible for paying a judgment. And the Lewis and Clark decision goes even further and specifies that tribal indemnification agreements. So if there's an agreement in this particular case, and I'm not sure if there is one, where the tribe says they'll repay any individual defendants for any judgment entered against them in their individual capacity, that also does not invoke tribal sovereign immunity.
What were the facts in the Lewis case?
You know, I apologize. I don't remember what the specific facts were in that case. briefed a lot of cases in preparation for this. I remember the legal issues that came up. I know more of the specific facts of some of our other cases that we'll discuss today, but I don't know. And if there aren't any more questions, I'll go on to tribal sovereignty, which I think is one of the hairier issues and harder to understand, largely because I think it's been muddled in the case law over the years. It appears to have grown kind of in conjunction with and maybe slightly out of the tribal sovereign immunity issues. Essentially, tribal sovereignty as a defense asserts that, as a matter of comity, is it appropriate for the state court to exercise jurisdiction, and if doing so, would, or not just the state court, but often these cases come in the aspect of states trying to impose the regulatory schemes on tribal lands. Does the exercise of jurisdiction in this particular case interfere with the tribe's ability to regulate itself and its members on its land? And that has shifted a lot over the years. There's a lot of cases that were cited by the appellees in this particular case. I think you'll notice that none of them are newer than 1987. That's because there's been a lot of shifting around in the case law, especially out of the U.S. Supreme Court, on sovereignty issues. The Iowa Mutual Insurance Company versus LaPant case in particular is one that's relied on heavily by the appellees. That one, the language that they relied on has specifically been ruled as dicta by the Supreme Court in later cases. Now the concept of tribal sovereignty has kind of shifted. We are looking at various factors, and it's not a white or black thing. There's some aspects of tribal sovereignty that are completely exclusive of state sovereignty. There's some aspects of state sovereignty that are completely exclusive of tribal sovereignty. And then there's this gray area, the gradient, the sovereignty gradient, as I refer to it, in between, where there are many opportunities for concurrent jurisdiction of both the tribe and the state. And tort claims between private parties is one of those areas that has been addressed in the case law.
But don't all of the tort claims essentially go to the whether the contract was wrongfully rescinded, or this seems like it involves all activities that occurred on the reservation and go to this contract between the tribe and your client.
Two things on that. One, not all the activities were on the
Which activities? Is there anything other than the interview with the Arizona Republic? Are there any other activities that occurred off the reservation?
Some of the activities we don't know where they occurred, given that we're talking about what the individual defendants did at different times. Not all of them live on the reservation. As far as I understand, only 3 of them live on the reservation. So if they entered into communications or discussions with other members in this wider conspiracy, and they didn't do it on tribal land, then they were off.
But isn't it a conspiracy relating to the contract that's between the tribe and?
And that was obviously the second issue I was going to address, and the answer is no. It's related factually in that the agreement and whether there was a breach is in the factual predicate of the claims being involved. However, interpretation of the contract and whether or not there actually was a breach is not a relevant element to any of the claims.
Well, your client agreed in the contract that the contract, and I assume any dispute arising out of the contract would be governed by tribal law. Is that correct?
That is incorrect, actually. And
well, then what is governed by tribal law and what isn't governed by tribal law?
And I'll tell you right now. And this goes into the issue of whether or not the amended agreement controls for things like statute of limitations and venue. Specifically, they have a choice of law provision, section 15.4 of the amended agreement, chooses law and venue for litigation under the amended agreement. For any litigation under the agreement itself, which this is not, that would be the tribal court litigation that had already occurred. and to civil or criminal matters arising out of services provided. Now, the only party that provides services under the contract is Western Destinations. None of the claims involved here have to do with the services that Western Destinations is providing. It has to do with the conduct of the defendants in this particular case, the tribal defendants.
But as I understand the facts, the tribe was claiming that the services were not done correctly under the contract. That's why they were trying to rescind the contract.
The tribe also alleged that in their default letter. However, that aspect, whether the tribe believes it's a default or not, is not the function of this particular case. Whether there was a conspiracy possibly leading into what the tribe did later on.
But assume that the tribe is correct, that the services weren't properly provided. If that's the case, then wouldn't your client's claims fall?
That's not true, because not everything has to do with whether or not there was an actual default, statements and representations about whether there was a default. There were other statements made, particularly the Arizona Republic article is one good example of that.
But aren't they related to whether there's a default?
They are related, again, factually, but not on the legal aspects here that are required to be found to prove up any of the claims being brought by Western Destinations. Additionally, beyond 15.4 of the amended agreement, there's section 1.1 of the amended agreement, which is where related parties is defined. Now, the only reason the agreement applies to any of the defendants here in this particular case is under this definition of related parties. However, that related parties language is not used in the choice of law and choice of venue provisions under section 15.4. It is used in other places in the contract, for instance, in the indemnification provisions of the contract. So it evidences an intent not to include related parties, such as the defendants, in the scope and purview of the choice of law provisions.
Counsel, something that I've been thinking about is, regardless of the specific arguments you're making here, this matter has to do with tribal property, what's done on tribal property, done by whom. It seems to me that if we're weighing the tribal interest against the state's interest, that the tribe's interests would weigh very heavily here.
The tribe's interest would weigh very heavily if we were dealing with a breach of the contract claim, just because, again, the factual predicate involves things happening on tribal lands or involves defendants who may or may not be members of the tribe, doesn't necessarily mean that the tribe is that particularly interested in it. And that's where we get into the case law that talks about...
What if the actions are being undertaken on behalf of the tribe? Couldn't we draw that conclusion from these tribal members acting, their actions seem to be for the benefit of the tribe, or at least to further the tribe's interest? Does that change your analysis?
That would only change my analysis slightly, and that's certainly what the defendants would want you to believe happened. However, one, we're talking about illegal acts here. These are ultra vires acts. I don't see how it could really be in the benefit of the tribe's interest to do illegal acts. Normally that takes one out of the scope of the duties of being a board member or whatever. Two, we have one particular defendant, Mr. Charles Vaughn, who was the one-time member of a tribal council. The tribal council is not involved at all in any of these issues. Now, ultimately, could the tribal council step in and take over for the tribal corporation? Sure. But it didn't do that. It didn't take any official action. So everything he does is completely separate from any concept of tribal involvement.
if you are successful or were successful in your claims against these individuals, it would require the tribe to do things that it doesn't particularly wish to do, correct?
No. If we were successful, we would get a monetary judgment. If there is an indemnification agreement, and I think there probably is one, then the thing it doesn't want to do is have to pay for that indemnification. But beyond that, the tribe isn't required to do anything. The cases, there was two more cases regarding tribal sovereignty that I wanted to bring up specifically. That's the Smith v. Salish, I apologize for pronunciation, Kootenai College is Ninth Circuit case, as well as the Astorga versus Wing case. Those are both cases involving tort claims between private individuals, just as we have here. In both of those, it was found that there was concurrent jurisdiction between the state and the tribal courts. So it could have been brought in either location, according to those two cases. I believe we already addressed whether or not the amended agreement applies to forum selection and venue. I don't think there's anything new to add to that beyond that. That brings us to the failure to state a claim / leave to amend and dismissal with prejudice issues. Again, there's a lot of complicated parts here. The allegations made by the defendants as to the fraud claim is that there was no reliance on a false statement or ignorance of falsity. And here I'd like to correct a mistake in our reply brief at pages 19 to 20. There's a paragraph that doesn't make any sense there because we talk about their knowledge of the falsity of what they're saying. I apologize for that. That was just a typographical error. However, the following paragraph deals with the reliance issues, and it covers the same thing, whether or not there was an expectation that Western Destinations understood those representations to be false or not at the time it was relying on them. And it was not. And specifically with respect to those representations, again, this is at pages 20 and 21 of the reply where we go into more detail. This is mostly the work of Defendant Penny and Defendant Turner. We talk about the reliance on representations that the issues would be discussed with Western Destinations before the tribal corporation did anything more. The promise to get them on the calendar to be discussed with the GCRC. Then there's issues arising out of the default letter itself, which has statements being made by the collective members of that board don't appear to be true. There was reliance on the assumption that the defaults being alleged therein, there may have been some basis. In the past, there had been other defaults alleged. The Western Destinations came in, satisfied the tribe that those had been corrected. But in this case, they were so vague in the default letter that there was no way for Western Destinations to even know exactly what they were talking about in many instances. And so they were relying on the representation as suggesting that there may actually have been a true default somewhere in there, but they would get a chance to talk about it with the GCRC members to basically explain to them, what are you talking about?
That seems to be clearly a contract claim, isn't it?
Whether or not there's a default associated with that, but whether or not these things actually occurred is another issue. And they were making representations that there were these problems. For instance, they said there was a barn that was essentially condemned and could not be used, and that it would have to be remedied. Well, there were certain steps that had to be taken through the GCRC before they could do that. But in reality, after the contract is canceled, months later, without any changes being made, they're continuing to use that barn just
That's
as
a
if
claim
nothing.
that presumably would be raised through the forum that was selected in the amended agreement, which would be in tribal court.
As to whether it's a default or not, But whether there was actually a building that was condemned and could not be used, that's a factual statement and did not need to be brought in the tribal court as part of the...
The factual statement doesn't get you anywhere without, you're saying there's an independent remedy for an incorrect factual statement apart from the contract?
Yes, I am.
Could I ask you on the dismissal with prejudice, what in your view would be different, or how does that harm your client at this point?
Well, dismissal with prejudice prevents Western Destinations from refiling the claim under the savings statute and correcting any of the deficiencies that may have existed if we can identify what those deficiencies are.
Well, if the problem is tribal sovereignty, and assuming that's the basis, there's no way that you can amend the complaint to get around that.
Correct. There's no way we can amend to get around that. However, that's why we're here today, is we believe that the trial court erred as a matter of law in saying that there was no tribal there was no sovereignty of the state court to hear these claims. And I would really love to reserve the last 20 seconds of my time if that's possible.
Thank you, counsel. Mr. Kaufman.
May it please the court. My name is Sam Kaufman. I'm joined by Mitesh Patel. We also have Eileen Gilbride of the Jones Skelton firm. We represent 9 tribal, what we've identified as tribal defendants in our pleading. Ms. Gilbride represents 1 tribal defendant, and she is joined with us and is joining with us in our presentation today. The trial court in this case established 5 bases for its dismissal, all of which independently provide that any one of them results in dismissal of this case. And tribal sovereignty is a starting point. And the case we've relied upon, and it's never been challenged, is the Williams v. Lee case. And in that case, it arises out of Arizona, where a businessman went on to the Navajo Nation reservation and did business with a Navajo couple. And the court in that case ruled that the state court simply had no jurisdiction in this matter. They established a test which said whether to allow the exercise with state jurisdiction would undermine the authority of the tribal courts over the reservation affairs and hence would infringe on the rights of Indians to govern themselves. So the test in Williams v. Lee is whether it involves its right to govern. Immunity is an absolute block, but tribal sovereignty is the right of it's the right to govern their affairs on their tribal reservation. And I would submit that in this case, our facts involve far more affairs of the Wallapai Indian Nation. And just to clarify, 7 of our clients were ex-board members of Grand Canyon Resort Corporation, a wholly owned tribal corporation of the Wallapai Indian tribe. One of them was an ex-executive, and one of them, Mr. Vaughn, was a tribal council member.
Counsel, how is a court action against individual tribal members, how does that affect the tribe's right to govern itself?
Well, it affects it in many ways because they've made allegations that all levels of tribal government have been involved in a fraud against the plaintiff. Their statements, for example, that this matter, that when they were talking about Charlie Vaughn being a council member and none of this pertains to the tribal council, let me take you to paragraph 166 of the complaint, which says, on information and belief, the GCRC defendants, Turner, Charles Vaughn, and the council intentionally, fraudulently and maliciously ignored Western Destinations correspondence and notice of intent to cure and intentionally refused to respond until after the passage of the 30-day deadline announced in the default letter. So they've made allegations that clearly pertain to the affairs of the tribe. They've literally alleged that the tribal council member, tribal board members were all involved in a fraud to remove them from the tribal reservation.
But the action is not against the tribe, though.
It's not against the tribe, and that's an issue that may be for tribal sovereign immunity, but for tribal sovereignty, when events take place on the tribal reservation, tribal courts have the right, and that's exactly what Williams said, that they talk about over sovereignty of the affairs of their corporation. So the notion that they can go into the Superior Court of Arizona and allege all of these tribal conspiracies against the tribal council, against tribal boards and tribal individuals, those are their claims. They involve allegations of reports to the tribal police. That's the horse incident that's referred to over and over in the complaint.
Would that principle apply to simply a car accident on the reservation, a tort claim arising from an automobile accident?
No, in fact, there's one of the cases that they cited to, which was the Straight VA Contractors. Very good example where there was an accident between two people on a reservation, and the court just said, the tribe has no interest in that. But here they've alleged every aspect of tribal government. It's a tribal business. They went onto this reservation and built a tribal ranch, cabins, and town. And the allegations, the focal point of this entire litigation is this alleged breach of the contract.
Is the focal point dispositive? If there were some just personal animus evidence by alleged slander or something that was just one, happened to be a tribal council member who just had a personal animus against someone and is just making slanderous statements, is the focus dispositive there?
In your example, it might be exception, but let me take you to count 4 of the complaint, which is repeated against all 10 tribal defendants. And this is count 4 says fraud, misrepresentation, Carrie Imus. It says the default letter contained representations of events, alleged events of default that the GCR board destinations knew were false and or the sole responsibility. So there's no question that they've tied directly the fraud and the breach of contract. They're not just related. Under their allegations, they're identical because there's no question Carrie Imus submitted an affidavit, and that's appropriate under 12B1 motion to dismiss, stating that the tribal board made a decision that they had violated the contract and tribal codes, which they agreed to be bound by, and and that was an authorized letter terminating the contract. And that termination is this entire lawsuit. Everything they've alleged pertains to that. It's obviously a disguised breach of contract claim. So, Judge, first of all, Judge Udall got it right that tribal sovereignty applied. Second, Judge Udall also found that that all of these tribal events dictated, both under tribal sovereignty and just as a matter of application, that tribal law would apply to events on the tribal reservation. I mean, they're seriously referencing to you a condemnation of a tribal barn. Well, condemnation is a governmental action, but they're alleging individuals somehow committed a tort by a tribal governmental action. So clearly, tribal law would have to apply. And the trial court made a substantive finding that, in fact, there was a 1-year statute of limitations under tribal law and that they were bound by it. So their claim, which came several years after the 1 year, or at least more than a year after the 1 year had expired, was untimely as a matter of law. Second, they had a contract that said they would be bound by tribal law and tribal venue. And both sides have cited the Farrell v. Minetti test of whether a non-party to an agreement can get the benefit of the choice of law provisions. And again, if you look at the complaint that I just cited, the test we both cited to is, are the tort claims related? Again, they're not just related here. The tort claims are identical. We send a notice saying you breached the contract. They immediately respond by saying, no, we didn't. And that becomes, and they call that then the repairs misrepresentation. So they're obviously, if the case had gone forward, the central focus would be, did they breach the contract? Because they're the exact same elements. So that provided the trial court yet another basis for dismissal, another basis for statute of limitations, and to enforce the venue provision of the case, which said that it belonged in the tribal court. We certainly do disagree with the notion that Lewis v. Clark is dispositive of this case. And the facts of Lewis v. Clark are this: a Mohegan limousine driver went off of the tribal reservation, was involved in an auto accident with unsuspecting victims who had no conceivable connection to the tribe. And the court in that case, the United States Supreme Court, held that merely acting within the scope of your duties is not necessarily equate with tribal sovereign immunity. But the reason our case is different goes to the ruling in the Wallapai Court of Appeals case. They filed the same case, and they've tried to act like they had in the Wallapai case, they filed individual claims, representative claims, but in our case, they're individual. That's not true. If you compare the complaints against the tribal board members, they're identical. But moreover, if you read the opinion of the the Court of Appeals, on page 13, the judge points out that they were making individual claims against the board members. And in fact, that's why they cited Pister v. Garcia for the same principle. But the Court of Appeals held that under the Wallapai Constitution, Article 16A1, that tribal sovereignty under the Constitution did include acting within the course and representation of your position, and it was broadly defined. Going back to Lewis v. Clark, again, unsuspecting tort people off the reservation with no connection to the tribal reservation. They didn't agree to any tribal law, and there apparently was no such tribal law. In our case, the plaintiffs went on to the tribal reservation and expressly agreed to be bound by tribal law. So if your question is, what is the tribal law and tribal sovereign immunity, you simply have to read the opinion now of the judge in the Court of Appeals for the Wallapai Court. And when the judge, yes, it's true, the exhaustion claim is out, but now we have, well, let me back up. So first of all, then, we know that the trial court was correct on tribal sovereign immunity because the Tribal Court of Appeals has now told us that his decision was absolutely spot on. They've also claimed that Charles Vaughn was not acting, that he was just a council member. In fact, this is that he wasn't acting in any capacity. If you go to their opening brief, they say it quite clearly. Charles Vaughn was only a member of the Wallapai Tribal Council for a period of time, and none of the conduct at issue involved any actual or alleged official action taken by the Wallapai Tribal Council. His extra legislative activities are unrelated to the source of his qualified immunity, namely actions taken by the Wallapai Tribal Council, and occurred outside of his official capacity, because the Wallapai Tribal Council was not involved. Thus, Charles Vaughn's status as a council member is purely circumstantial, and the court erred in dismissing the claims against him based on tribal sovereign immunity. And I mentioned this before. Let me take you back to paragraph 166 of the complaint. On information and belief, the GCRC defendants, Turner, Charles Vaughn, who's not only a council member, but identified in the Arizona Republic article as the former leader of the tribe, and the council intentionally, fraudulently, and maliciously ignored Western Destinations correspondence. So there's no question that they've alleged that Charles Vaughn was supposed to be responding to their efforts to cure the contract. In fact, they're alleging that the tribal council should have been doing that. So based on their own pleadings, it's clear that the ruling, even though they added Charles Vaughn as a defendant in the Maricopa County case, under issue preclusion, it's very clear that the ruling of the Hualapai Tribal Appeals Court does in fact cover Charles Vaughn because it's the same allegations being made. And I would certainly suggest to you strongly that even though the judge didn't get to the issue of whether these allegations stated a claim, the only reference to Charles Vaughn is this reference and also the Arizona Republic article. And if you look at that article, there's nothing remotely that states a legal claim. He literally makes statements in favor of tribal sovereignty. It's not a claim. And in fact, their claims of, they've told you that they should have been able to bring these fraud and misrepresentation claims and talked about the right to rely. But from their own complaint, it states they got notice from the tribal board, you are in breach of this contract in these particular ways. They respond and say, no, we're not. They didn't rely upon anything the tribal board said. They immediately said you're wrong, and in fact claimed fraud because apparently the tribal board didn't respond to their efforts to cure the claim, to cure the breach. Now, the tribal, I would submit that if, for example, you believed that Lewis v. Clark somehow changed tribal sovereign immunity, and I don't think it does because our case is so distinguishable because they agree to be bound by Hualapai law, and you have to go to the Hualapai tribal constitution. But even if you agreed, that doesn't change our case because we now have a dispositive ruling on that issue. And as the trial court in this case noted, it is not. The Arizona Superior Court is not a court of appeals for the Hualapai Indian court system, nor is this court a court of appeals for the Hualapai Indian Court of Appeals. It's simply not. So when Judge Udall recognized that decision, now, and he was recognizing the decision of the trial court, we now have the Court of Appeals dispositive ruling, and you can take judicial notice of that ruling, and yet it provides another basis for the dismissal of the claim. Two items procedurally. They've suggested to you, well, and let me, I do want to address a couple of the sovereign immunity cases. They've suggested we relied on old cases. Williams v. Lee hasn't been in any way overruled. The cases they've cited do not change the analysis in any event. The two cases he mentioned, the Astorga, the plaintiff himself was a tribal member moving in state court. And the courts have ruled that a tribal member has a dual citizenship and they have the right to move in state court if they wish. The Smith case actually upholds tribal sovereign immunity. They seem to rely upon a footnote talking about concurrent jurisdiction where somebody agreed to concurrent jurisdiction. Two final points. They've alleged that they should have been permitted to amend. They have not shown you, if you look at the pleadings, any citation of the record that they even asked to amend the complaint. And under the case of Blumenthal v. Tietz, which we cited, asking to amend under amended Rule 15 isn't even sufficient. You have to show the court how you would amend the pleading. So they didn't even do what is insufficient, is just say we want to amend. And they certainly didn't do what Blumenthal v. Tietz said, which is to show the court what amendment you would file that would change the court's decision. Finally, on the motion, the issue of whether it should have been dismissed with prejudice, they've cited a number of cases talking about dismissals under lack of jurisdiction, where you're not deciding on the merits. Well, first of all, they didn't raise that in the trial court. The court made an order, and they submitted a judgment that made no comment on the dismissal with prejudice. Second, these cases about jurisdiction are overlooking the fact that Judge Udall in this case actually made several substantive decisions. He not only found that in favor of tribal sovereignty and lack of jurisdiction, but he also found on several bases that the law of the Wallapai tribe had a 1-year statute of limitations. And he was certainly able to, like many state court judges, apply the law of a different jurisdiction to his facts. So he found that it was untimely as a matter of law. He also interpreted the contract and found in favor of the statute of limitations. So it was not merely a ruling of lack of jurisdiction. He made substantive findings that even if you disagreed that he had jurisdiction, he also ruled that the claim was untimely, applying the appropriate law in the case. If you have any questions, I'd certainly be willing to address those.
I believe so. Thank you, Mr. Kaufman.
Thank you, Your Honor.
Mr. Bernheim?
With 17 seconds left, I'll try to race through a couple of things here. First, the Wallapai Constitution and court rulings can't override the U.S. Supreme Court decision on sovereign immunity. Issue preclusion was waived. It was not raised below. That's an affirmative defense, and it doesn't apply here because there were different issues and different parties involved. And I thank you for your time.
Thank you, counsel. Thank you for your briefs. On behalf of Judges Catani and Howe, I thank you for your briefs and your presentation today. We will take the matter under advisement and issue a ruling in due course. We will now be at recess. The judges will stay on the bench and allow the parties in the next matter to come forward and get ready, but we'll be at recess until they are ready. Thank you.